Good afternoon. My name is Greg Lois. Thanks for joining me in your summertime to talk about everybody's favorite topic, which is New Jersey workers' compensation law, which we all love. And in particular, today we're going to talk about medical provider claims, which are something that are near and dear to my heart. I absolutely hate medical provider cases. And so as I talk about this today, you're definitely going to hear some of my bias about the way I think about these cases and how frustrated we all are with them. My goal today is to explain this topic and then give you some ideas, like things that you can bring home and hopefully do something successful with. Welcome. Today is August 11th. And if you're here, it's how to defeat medical provider claims in New Jersey. And I know that sounds a little mean. Maybe I should have said how to win them, but that's our goal. How do we win these things? How do we shut them down? How do we get them to conclusion? And more importantly, like, how do we try these cases? We have to try them to conclusion. How do we win them? And so today in the handouts, I printed out and I sent you a lot of case law that's in the handouts, but these are not like trial decisions. These are decisions that were based on law. So I'm going to talk today about how we win at trial, how you actually prevail at trial, and what prevailing actually means. Just as a reminder, this is a presentation. This is not legal advice as to any matter. My outlook, just to share the perspective of Lois Law Firm, is our mission is to take control and stay in control of our Jersey cases. We want to drive these cases to quick closure. Okay, that's our goal. So when we talk about this topic, I'm not going to talk about this as like a legal academic. I want to talk to you about it from a practical perspective of how to keep these cases moving forward to some direction. Everything that I'm talking about today is in my handbook. There's an excerpt today in the presentation notes, which you should be able to access through the chat. I write the handbook on this with my co-author, Richard Rubenstein. Every year we update our handbook. And what's useful to you in today's handout in the notes is a copy of all of our form discovery. So I get a lot of questions from counsel, other respondents counsel, like, Greg, what do you do for interrogatories? What discovery do you serve in these cases? Well, I added that today into your handout, so you should have all of that. So if you're looking for form interrogatories or form discovery, that's the discovery that we use. After attending this presentation, you're going to understand what a medical provider claim is, what discovery is allowed, how we handle these cases, sort of how we think about them in terms of a decision tree, how we defend them, and how we win a trial, and what defense counsel should be doing when you try these cases. What arguments should be making, and I'm going to drill into specifically what words do you need to say and put in your brief so that you ultimately prevail. So I organized this presentation basically into three parts. The first part is what is a general medical provider case. Then I'm going to dive into a little bit the specialized area, which is jurisdictional cases. We're going to talk a little bit about how cross-border medical provider cases resolve. In our practice, it's predominantly defending, or at least half our practice is defending cases that began as New York workers' compensation cases and ended up here in a New Jersey workers' compensation court. So how do you win them? What are the trial rulings that we're seeing? What's the appellate division saying about those cases? And then I'm going to end by talking about our trial tactics. What is the other side? What does the medical provider have to prove? How do they prove it? What do we have to prove? And what are the types of documentation and evidence that we're going to produce a trial? And what kind of witnesses do we need? And how do we cross-examine their witnesses? And how do we present our witnesses? So that's really the goal for today's presentation. Now, this is completely and totally live. It's unscripted. So if you have questions, go ahead, type them to me. I will go at the end and I'll answer all the typed questions. I will then also open up the meeting after my formal remarks are concluded, and I will take all your questions that I can live. And it doesn't have to be just this topic, by the way. If you have questions about literally anything in New Jersey workers' compensation law, feel free to ask me. But go ahead and ask that question. I won't embarrass you. I will try to give you the best answer I can. Just remember, if you're asking questions, please don't give me the name of your case or the claimant or opposing counsel in your case, because I'm not your counsel. I just want to give you general responses. All right. Let's talk about these kinds of cases. Roughly 20% of all the new cases filed in the Division of Workers' Compensation are now medical provider cases, which is kind of amazing considering they didn't exist before the year 2012. They're officially called medical provider application for payment or reimbursement of medical payment, and are allowed under the statute. But we all just call them medical provider claims or MPCs. There is no petitioner. In fact, most of the times the actual petitioner, the actual injured worker, has no idea these things are pending. It's just the medical provider suing you, the employer or the carrier, saying you owe me more money. And every single one of these cases, the medical provider says, you have underpaid me and I am due money from you. Now, they are able to do this because the Workers' Compensation Act specifically authorizes it. Remember, in New Jersey, we have no medical fee schedule. So what we do in New Jersey is all of the medical providers who serve employers and carriers, they have a contract with us, right? They're under a contract. We're picking the doctors, so we make sure we pick physicians that we have a contract with. But in these instances, these are circumstances where there is no medical contract in place. And so oftentimes what you see is a medical provider bringing a claim for emergent medical care that we did not direct and control. So that's a big portion of these. And the other portion of these are extraterritorial cases in which someone got injured in New York, working for a New York employer, had a New York workers' comp case, and then crossed to the river and got medical treatment in New Jersey. Sometimes innocently and sometimes not so innocently. So those are the genesis of a lot of these cases. Now, the New Jersey statute says that where there is not an agreement between the employer or the respondent and the medical provider, that the medical provider is allowed to charge usual and customary. That's a nightmare because that means they can just make up anything they want. And you'll see in New Jersey tremendous numbers. And I'll go through some examples of crazy, crazy demands for reimbursement for medical costs. I mean, just above and beyond anything that's conscionable. The jurisdiction for these claims has now been decided to be 6 years. That's the same jurisdiction, by the way, for contract disputes in New Jersey. That is longer than the jurisdiction to file an underlying workers' compensation case in New Jersey. In New Jersey, the statute of limitations for a workers' comp case, okay, an accidental injury case, a work accident case, is 2 years from the date you knew or should have known of your accident or occupational exposure. Okay. 6-year statute of limitation for the medical provider to come forward is really scary. And one of the reasons it's scary is because of all these COVID cases that occurred in New Jersey where maybe the person never filed a New Jersey workers' compensation case for COVID, but they're still within the statute of limitations, the medical providers, to bring claims against you. And that's where I've seen some real abuse. Cases where the petitioner didn't bring a COVID claim against their employer, but the hospital that treated them and maybe racked up a bill of $200,000, then brings a medical provider application. So that's a real challenge. But the burden is on the applicant to establish that the treatment is related to a compensable workers' compensation injury and that the New Jersey Workers' Compensation Court would have had jurisdiction over that injury. So that's what they have to show in order for them to bring these cases. And again, the actual injured worker does not have to bring their own claim, and in many cases does not and has no idea. Now, there's one other interesting wrinkle about medical provider claims in New Jersey. One other thing I think that's a little bit unique about them. There is no direction or rule or statute or case law that determines how much the applicant attorneys, the people who bring these suits on behalf of the medical providers, are allowed to be paid. That's interesting. Now, just remember, 2 years ago, they just changed the statute, and it just went into effect this year, in 2024, for how much petitioners' attorneys' fees are. Now they've raised the fee for petitioners' attorneys to 25%, which strange is there is no similar ruling on fees for applicants' attorneys. And the reason I bring this up is this is a fertile area for us to litigate and challenge them. In other words, to say, well, you say you represent this applicant, prove it to me, because I want you to bring them to court and have them testify in furtherance of their case. But I also think it's interesting that they're allowed to take a fee that's not controlled or allegedly not under the control of the workers' compensation law judge. I think that's an area they're vulnerable on, and I think that's something for us to explore. Now, in these medical provider claims, the medical provider must say, hey, I provided treatment to your injured worker. They could have brought a New Jersey workers' comp case, even if they didn't. and here's the amount in dispute, and here's what you should pay me. Now, look at what I'm showing you on my screen here. This is an actual case that I'm defending, that I defended. The date of injury is 2012. The date of last treatment was 2019. And look at what this doctor billed for this 1 day of treatment. Now, look, you see 2 dates of treatment there, but they're actually the same date. And they said on April 18th, 2019, I provided medical care to this person and the medical care was 2 people, 2 surgeons, actually co-surgeons, who billed $180,321 each for the back fusion surgery that they provided in this case. That's right, $360,000 divided between 2 surgeons equally for this back surgery. Now, look what my client paid. Look what the carrier paid, roughly $25,000 for that surgery. And there was a big dispute in this case. And this was actually, the dispute in this case was, hey, there was no jurisdiction in New Jersey. This should have been brought as a New York workers' compensation case and paid under the New York medical fee schedule. But I just want to point or direct your attention to how crazy, how high the fees can be for some of this medical treatment that we're seeing. $360,000 for a 1-hour surgery is pretty insane. Also, just pointing out here, the idea that there's 2 surgeons who are billing identical amounts for the same surgery is also highly problematic. And we'll talk about that in a little bit when we talk about trial proofs. Now, I want to remind clients out there that are listening to this, and really everybody, having a medical provider network out there is important so you can avoid some of these medical provider claims. If you have a medical provider network, either as a carrier or a self-insured employer, you at least have a strong argument that, hey, if we directed this person to you to undergo care with you, that the fees or the negotiated rates that we have under our medical provider network should control. And even if we didn't, in other words, even if this person sought emergent care with you, medical provider, you also recognize that you already have this pre-existing contract with us, and that should control what the costs are. So that's one very important step. And I mean, it's prevention. An ounce of prevention is worth a pound of litigation, in my opinion. So everyone out there who's paying attention to this, carriers, self-insureds, make sure that you have a provider network in place in New Jersey. And there's a lot of them. You don't have to go out and, by the way, do the work to build your own medical provider network. You can rent one, okay? And they're very easy to do that. Now, in the context where you don't have a contract or there is no provider network, because New Jersey does not have a medical fee schedule, the statute says that the reimbursement to the physician or surgeon or hospital or medical provider, it really could be anyone who's taking part in the care of this patient, should be based on the, quote, usual fees and charges which prevail in the same community, close quote. Now, that is a slippery statement. It's vague, it's broad. What are usual fees and charges? And this matter had to be litigated. We had to determine this in court and come up with a court decision. The courts are the ultimate arbiter of who's going to decide fees and charges, right? That's the person that's ultimately going to figure this out. How do they do this? Well, there is the first reported decision on this was called University of Morristown Burn Surgeons. That case, the judge of compensation who decided that case, Virginia Dietrich, said, hey, let's look at the medical billing, what actually is typically paid by other payers, by all payers for that same type of treatment. So what's developed here is the inquiry has to be, hey, what did the same insurance carrier or employer pay in the past for identical treatment? What another insurance carrier or employer paid in the past for the same, and when I say same, I mean identical treatment, same CPT code, same everything. And then if you don't have that, we could look at other sources. We could look at, hey, what did a private health plan pay? What a cash payer would pay? What does the hospital publish as a fee or rate? Remember, since the Affordable Care Act, Obamacare, every hospital is required to publish on their website a statement of all of their published fees and costs for every service that they provide. So you can go to that. We can look at what Medicare or Medicaid would have paid, particularly if that provider accepts Medicare or Medicaid patients. And what I like to look to is New Jersey's fee schedule for personal injury protection. That's motor vehicle accident cases. I know it's strange that in New Jersey, workers' compensation doesn't have a fee schedule, but motor vehicle accident cases do. So I often will say, Judge, look at the treatment under the motor vehicle accident case fee schedule. That's been accepted by all of these physicians and hospitals and providers. Can't we just apply that? And the reason I suggest that is because it's pretty favorable and it's pretty fair, right? And we can easily establish that. Again, that's the circumstance when we don't have a contract. Now, keep these ideas in mind, like what we're going to look at when we talk about what discovery is and what discovery needs to be conducted or can be or should be conducted. Now, I also want to keep some perspective around this. And the perspective is New Jersey sits in the middle of other states. Some of them are a lot bigger. But New York has a fee schedule. Pennsylvania has a fee schedule, right? Look to New York fee schedule. A knee meniscal repair, arthroscopically repaired knee. The New York fee schedule currently pays about $5,800. In New Jersey, you will see medical bills about 10 to 1, about 10 to 12 times higher than you're going to see in fee schedule states. And by the way, some procedures you're seeing even bigger than that. And that's because medical providers in New Jersey are absolutely taking advantage of you and trying to draw in patients from other neighboring states that have fee schedules. So just keep in mind how out of control New Jersey's medical costs are. Now, if you don't have a contract, you're still allowed to reprice these bills that come in. And most of our clients and most of the people that we work with here have some sort of repricing scheme in place. They'll issue an explanation of benefit and say, essentially, hey, we looked at your bill. Here's what we think we should pay. Here's what we're prepared to pay. That means that my job then shifts, if there is no contract, of course, to defending the work of the repricer and demonstrating that the work of the repricer is accurate and fair and should be adopted by the judge in this case, okay? When we talk about trial proofs in a minute, I'm going to talk about exactly how we go about doing that. Now, these cases are going to resolve one of two ways, really three ways, I guess. First is you can just get an abject dismissal. We've been very successful about getting these dismissed, particularly the jurisdictional ones. They can compromise, you can settle them. You can pay a few pennies on the dollar. That's also a very valid approach. And then the last opportunity is to say, you know what, we want to try this case. You present your proofs, we'll provide ours, and let the judge make the decision. Now, judges do not like this approach. And my estimation of opposing counsel is they don't like this approach either because they are spread super thin. They are not responsive. They are handling thousands of these cases per attorney, and they have no capacity to actually try these cases to conclusion. Okay, shifting down to that discovery, because remember, the parties have things they have to prove. Opposing counsel has to prove that the underlying injury would have been compensable under a workers' compensation law and that New Jersey has jurisdiction. But they also have to show, hey, that this is reasonable and necessary medical care that was curative in some way. And then they have to justify their bill. So they have a lot of things they have to prove. Now, interestingly, even though the statute was amended in 2012 to allow these cases, it was not amended to allow any discovery. So there is no statutory or rule-based discovery that we can point to. I know you're saying that sounds insane, Greg. So they created this whole class of cases, but they didn't give you any disclosure tools so that you can look into this. And the answer is no. And what we began to do is start issuing interrogatories to the opposing counsel. We say, hey, okay, you're saying that we're underpaying you. Prove it to me. Show me all the places where you've been paid more money. We did this by way of asking for answers to specific interrogatory questions. Opposing counsel opposed this. More and more litigation ensued. Ultimately, and this is the strangest thing that I've seen, is that the chief judge issued a memo saying, hey, we're not going to allow interrogatories unless you file motions. It's like the courts there are not allowing people to self-help. They're saying, make us get involved. Regardless of this, we often have to, in fact, we have to, in every case, file a motion to compel the other side to provide us with the discovery that would then demonstrate that they have a valid and valuable case. It sounds insane, but that's what we have to do. Our discovery goal in every case, though, is the same. I want to see what they were paid for this identical procedure from as many other payers as possible, as many other payers as I can possibly get. I want to see Medicaid. I want to see private payers. I want to see that they accept motor vehicle accident cases, personal injury protection cases, right? I want to see all of it so that I can make my best argument. Now, the thing that we need to focus on in our discovery is what they have been actually paid, not what they've billed other people. And in fact, in their answers to our interrogatories, they'll often send us these reams of bills that they served on. They'll say, look, here's 9 other workers' comp carriers that we billed the same amount. I go, I don't care what you billed. I care what they paid you, right? That's the important thing. And so that's what you need to refocus them. Now, that's the typical case. Now, the jurisdictional case is a little bit interesting, and this has been just developing and developing and mushrooming and mushrooming. This is providers who are really sneaking patients across state borders on a lot of occasions. And when I say sneaking, I mean they're literally putting them in limousines from New York City in Manhattan and sending them over to New Jersey. If you think I'm exaggerating, I'm absolutely not. There are practices that are taking claimants from Brooklyn, putting them in limos, taking them over to Bergenfield, New Jersey, which actually isn't that far from where I'm standing in my New Jersey office, to have the procedure done in New Jersey. Why? Because New Jersey doesn't have a fee schedule. So they're shipping people across the border. They're doing it on purpose. And again, getting back to what I shared with you earlier, they're going to get paid 10 times as much, 12 times as much, and in some instances, 20 times as much in New Jersey for the same procedure. This is why we have so many of these filings. That's why there's so many of these extraterritorial disputes. And there's a lot of inconsistency. Now, I want to walk you through a typical case. Claimant, injured in New York, employed in New York, happens to live in New Jersey, so gets medical care in New Jersey. They're not really doing anything nefarious, just happens to live here. He proceeds under his New York workers' comp case, gets an award of permanency, all those things. But a medical provider brings a case in his name here in New Jersey saying, I'm entitled to reimbursement at New Jersey's rates. We made an argument, and this was really the beginning or the snowball of this, of, hey, New Jersey actually has no jurisdiction. You can't even hear this case because you don't have jurisdiction over the underlying case. We argued that residency alone in New Jersey is insufficient and treatment here is insufficient. We wrote briefs on this, we argued this, and we prevailed. Okay, we prevailed. And since 2023, this has been your best argument as to why you should not pay New Jersey usual and customary rates when a New York or any other state employee crosses into New York and crosses into New Jersey, I should say, and gets medical care here, right? That's a strong argument for that, and that we've been prevailing on that. So if you have that circumstance, I have the case law right on point, and I put it in today's meetings. Since then, there's been some additional authority, and there is some associated authority that you can point to. There's a case that was decided in November of 2023, so roughly 9 months after Watrick, which essentially has some of the exact same ideas in it, Hudson Regional Hospital versus New Hampshire Insurance Company. And again, I put that in our handouts. What's interesting to me is opposing counsel is not appealing on the issues of these jurisdictional disputes. In Hudson Regional, they tried to characterize these as contract disputes to get around the fact that they don't really have a jurisdictional basis for these claims in this court. So my advice to you is if you have a case in which the claimant was injured in another state and is now getting care in New Jersey and then files a medical provider claim, you probably have a very strong defense, and that's one that should be defendable. You also need to be prepared to argue against whatever opposing counsel, and I mean the applicant's attorney, is going to argue as to why the workers' compensation court in New Jersey should decide this issue. And a lot of what they argue is, Judge, if you don't do this, it's not fair. This is a New Jersey medical provider, and they should get the benefit of New Jersey's laws. Judge, if you don't give them more money now, they're going to be out of luck. They can't pursue a claim in New York or any other state. And, you know, I make very pointed arguments, and we have a briefs on point on this, and you could see that in the Watrick decision. It says, no, actually in New York, under its fee schedule, Ground Rule 16 says out-of-state should be paid at fee schedule, subject to an adjustment. I also argue that New York State retains jurisdiction. So if they feel like they were not paid enough under New York's fee schedule, guess what? New York retains jurisdiction. There's case law on that. It's the Bauman versus J&J case in New York. I know this is a New Jersey webinar, so I'm going to not, I didn't include that, which says specifically that the board has concurring jurisdiction. So there is not a fundamental fairness argument that they can really make. You win jurisdictional cases in New Jersey by filing motions to dismiss. And in my opinion, you need to file that motion and support it with as much fact information as you can provide, can put together. I think it is table stakes to support that motion with at least the order, the notice of decision in the other state decision case to show the judge of compensation why you should win. And also, you need to go a little further and explain to the judge of compensation why the other state's law should apply and not New Jersey's. Okay. And the last thing I'll recommend, and I think it's, again, best practice, is to file a brief to support that motion as fully as you possibly can. But then you have to pursue the motion, because we know what happens with filed motions in New Jersey. They go nowhere because judges of compensation don't want to deal with them. They don't want to make decisions. They don't want to have a hearing on the record. They don't want to rule for you or against you. They just want to adjourn stuff. So then you've got to be, as an attorney, you've got to be an advocate, and you've got to stand up for your client and say, look, Your Honor, this is a simple matter. It's jurisdictional. It's a legal argument here. There's nothing that they're going to be able to argue that we can't contradict. Your Honor, make a decision, right? And so you have to push the court to make these decisions, and you should prevail. Now, jurisdictional cases are one thing, but how do you win the non-jurisdictional case? Or in other words, the standard medical provider application case, in which the provider is essentially saying, hey, I provided emergent care, or I provided treatment, and you didn't pay me enough. Okay, so let's think about that. Look at the facts in your case. Was there a New Jersey comp claim at all? Was the treatment authorized, right? If it was authorized, do you have a contract? If it's unauthorized, did they file a motion for med in temp that you lost, which is now putting you in this position where you have to pay this bill? Or did they serve you with a Benson letter, particularly for unauthorized care? Even if it's unauthorized, I want you to remember that if you had a contract, if you had a preferred provider network, that would still apply. So you would still get the benefit of your preferred provider network. Next, did you reprice that bill? I'm hoping you did. I hope you sent it to your medical utilization department and they said, hey, here's what we should actually pay. What scheme was used? And there's a lot of them, right? Some of them are more common than others, but like I'm going to give some examples for how we defend a fair health case, for example. And the last thing is, okay, what was the actual payment history? What payments did that medical provider get for those identical types of care? Not hypotheticals, not what they billed people, but again, what they paid, right? So these are the central issues that you're going to need to present and be prepared for so that you can try that case and you can win that case. So what this often comes down to is defending the repricement. Often there's a vendor, some of our clients are repricing in-house through a utilization department. Some are outsourcing it. Some are using like rented or lent or vendor-based repricement methods. I don't care which one it is, but that's a moment for us to work together because we need to understand how that repricing is done, right? So the argument, you make is, hey, repricement here was done, Your Honor. Your Honor should sustain the repricement as it is fair, appropriate, and just. And this does demonstrate what is usual and customary in this jurisdiction, in this community. Judge, this was a fair repricement and Your Honor should sustain what we did. That's your argument, okay? But then you need to go a little further. I mean, that's the argument. You need to back that up. And so depending on which repricement vendor you're using or scheme or how the utilization was done or where the comparison data came from, you need to be able to come forward and support that argument and say, look, Your Honor, we're going to present a witness. This witness is going to come in and show you how the database compares, whatever the numbers, 5 trillion payment, points, 5 billion claim records, 80 different private insurers, and this is how they they price these services. This is based on geographic relevant data, not arbitrary reductions, not 10% across the board or 50% across the board. You have to be prepared to make a winning argument as to why that data-driven repricement is fair, usual, and customary. And again, you want to constrain it to this jurisdiction, to this community, as close as you possibly can. So where you can get data that's going to be CPT code identified or ICD code identified, and then by zip code, by specialty, by the type of carrier that it's being repriced for, that's going to be very important. And again, you've got to be able to make a strong, persuasive, advocacy-based argument for the judge, because on the other side, you're going to hear the opposite. You're going to hear them saying, well, Judge, we bill everybody $2 million for this procedure and everybody pays us. Well, you're going to say, well, no, they don't. And here's how we're going to show that. When you're defending that repricement, you've got to remember, you've got to make the argument that, hey, while New Jersey doesn't have a fee schedule in place, and we get it, Other states do, Your Honor, so we could use that as comparison, right? New Jersey happens to be in between New York and Pennsylvania, which both have repricement done. And you could even make arguments and say, Your Honor, if you're, I'm sure you're aware that other states actually base their repricement schemes or strategies on some of these vendor provided data lists, right? So you can make these arguments, and it's something that you have to be able to advocate for to get the judge to pay attention to you and to, provide some. Um, we should also argue that there's some basic frameworks or basic boundaries in place. When we started off this presentation, I showed you a 1-hour surgery that they billed $360,000 for. Now, in a vacuum, the person comes and goes, yeah, I had a fellowship at, Columbia Presbyterian. I worked with so-and-so. I'm an expert. I did this great surgery. I am due all this money. That might make sense in a vacuum. But then, our argument is to say, hey, judge, there has to be a framework here. There is a generally accepted range for these surgeries, right? And that's where you're going to have to be able to defend percentile-based repricing or geographic-based repricing. And again, this is about being an advocate. These cases all go in the same way. They follow the general order of proofs in a New Jersey workers' compensation trial, which is set out in the court rules: appearances, stipulated facts, ruling on motions, right? Opening statements, testimony of the applicant. Okay, so now let's get into testimony, and then we're allowed to present testimony to contradict that testimony or rebut it. Okay, so that's how this works. Now, who has to testify for the medical provider? Well, it can be an office manager or a billing coordinator, and that's sufficient, by the way. They don't need to bring in the doctors, but they do need to bring in someone from the medical office to explain, here's the treatment we provided, here's why it was necessary and curative, here's what we billed, here's the amounts, here's how we usually and customarily do it, and here's what we get paid, right? Because that's the part that we're going to cross-examine them on. We want to be cross-examining them about what they're typically paid, right? And that's going to be the weakest part of their case, and that's going to be the part where we're going to attack them most powerfully. In the case that sort of kicked this all off, Burn Surgeons of St. Barnabas versus ShopRite, this was an extraordinary surgery. This was skin regrafting that was done to a horribly injured burn victim who was taken to this one burn center and racked up huge bills. In that case, the carrier that defended it, NJM, repriced the bill as best they could. And in response to that repricement, when the case was tried, they actually brought in a medical expert, Dr. Morano, who is a board-certified burn surgeon. And he testified, hey, these are complex cases. You've got to do lots of strange things when you are doing burn and regrafting. You've got to raise the temperature in the operating room to over 90 degrees, right? You've got to do all this weird, extraordinary stuff. There's co-surgeons that we need. And the reason we're doing that is we can do these surgeries really fast, graft as much skin on as fast as we can. They explained why that extraordinary care was necessary. That's important. And so when you're challenging the necessity of this care, and particularly extraordinary care or care that's out of the normal, you need to be thoughtful. Hey, maybe they do need to provide a medical expert, and maybe we need to have one as well. Who should testify for the employer? Well, look, I'm going to have some foundational testimony in place about what contracts we have with that provider, what we've paid them in the past. If we're defending a repricement strategy, I need someone who's good at explaining that repricement strategy. Typically that's going to be a repricement consultant, or it might be someone, employee of the carrier, who can say, here's how we do this, here's why we do it, here's the database we use, and here's how we do it, right? And then, of course, if we've had prior payment experience with that provider, we want witnesses who can verify exactly what we paid for the exact or identical treatment of care. What do the courts care about? Well, the first and the most easiest thing for them to look at, and the thing that should be the most persuasive, is what they was actually received by the provider for identical treatment in the past. The payments should be about the same time our treatment was rendered, not 10 years later, not 10 years before. If there needs to be justification for co-surgeons or extraordinary care, there needs to be some explanation about that. And any testimony that they're going to hear about what are the other sources of payments, like Medicare, Medicaid, personal injury protection, or other fee scheduled sources that provider accepts, right? Those things are all going to be important. All right. Appealing these cases as a strategy, by the way, I'm going to suggest to you, in the exception of jurisdictional cases, probably not that useful, except for a case-by-case basis. I do think that the current basis for judicial decisions would be affirmed if it ever was appealed and went up, which is, hey, we're going to look at what other people paid for the same treatment. I mean, that's a very common-based system. So I would tell you that these cases as a strategy is appeal a viable strategy, not really except for the jurisdictional type cases. All right, let's close out by talking about some barriers, some challenges you're going to see in defending these cases or fighting these cases. And then I'm going to talk about some red flags that I'm sure you've seen before. So the big barriers are judges unwilling to conference these cases, parties not ready to conference the cases. Those are the two big ones, okay? In most of these cases, this is either coming down to a dispute about a replacement. Both parties have thrown some paperwork at the judge and getting the judge to actually conference the case and say, here's how I think this case should be decided. When you think about that, when the judge's role, particularly where both sides have done a good job of documenting what they've been either paid by other carriers or employers in the past, or what they've paid other providers in the past, it's really the judge looking at these two things and going, which one of these is more credible? And they're not supposed to split the baby. They're supposed to say which is right? So that's a tough job. I don't really want to do it. It's a lot easier to cut out early and go play golf in the afternoons. And so getting the judges to actually pay attention to these cases when they feel, by the way, the judges feel like they're acting as bill collectors for these hospitals and surgery centers doesn't feel so good, right? The other challenge that we have to push through is the other side typically not ready to conference the case. They always say, well, I'm waiting for additional information. They adjourn these cases over and over and over again. So challenging adjournments, arguing, hey, judge, this case should not be adjourned. It should be marked not moved. We're ready. Remember, Your Honor, if you mark a case not moved, we're then allowed to move to dismiss the case, okay? The other thing I see now recently has been applicants demanding discovery from us, which is ridiculous. It's not our job to prove how much we've paid. It's their job to prove to the court how much they've been paid. That's not our role, okay? The other thing that I've seen them do is applicants filing these kind of boilerplate briefs full of just nonsense, constitutional law arguments, contractual law arguments. There's all sorts of crazy nonsense. If you look at the case that I put in the handouts, the Hudson Regional Hospital case, the appellate division literally says you're relying on stuff that you should not, and these arguments should not have been brought to the court. I mean, it's pretty clear that they're just grasping at straws. In extraterritorial cases, meaning my cases that start as a New York workers' comp case, and then they file a New Jersey medical provider claim, they always claim like, oh, they're waiting for other information, or their New York counsel can't get them something. And I'm like, Judge, look at my response or my brief. I've included everything that's been filed in the New York case. Please, Your Honor, let's just move ahead, okay? And then again, I don't even call it anymore a knowledge gap. There's just like a caring gap where the bench just doesn't seem to really want to move these cases forward. Look, if I was the director of the Division of Workers' Compensation or the governor of New Jersey, and I can wave a magic wand, I would just say, hey, everybody, once these things get listed on a motion to dismiss, they have to be either decided, either grant the dismissal or deny the dismissal, one or the other, and you can only adjourn it twice. Just make some basic silly rule so that these cases actually move forward. Now, some red flags to look for. Okay, you've got a New York workers' comp case. You've got a Pennsylvania workers' comp case. It spawns a New Jersey medical provider claim. And then these medical provider attorneys want to prey upon you because they think, hey, you don't know anything about about New Jersey workers' compensation law, so you're just going to pay this thing at full value. Do not ever do that. Okay, you have no obligation to do that. How about the usual suspects, right? There's some red flags that you should be aware of. The usual suspects are Surgicare, Surgicorp, Hudson Regional, Medical Ends Hospital. The list can go on, right? Metropolitan Crossing Hospital. All of these outpatient services, service providers, very questionable. They have a big hand or reach, particularly in New York. The other thing I see is New York doctors who've come and set up satellite offices in New Jersey only for the purpose of providing surgeries. That stuff is red flags, and you should be red flagging those cases. And then look for the suspect medical care. There's stuff that's really weird that in other states might not even be allowed. So it's a New York workers' comp case, and you see this bill for $60,000 for intraoperative neurodiagnostic monitoring. What is that? Well, it's somebody monitoring their heartbeat during the surgery. Okay, maybe it's important, but it's not worth $60,000. And when you really dive into some of those bills that we've seen for intraoperative monitoring, the person, the neurologist or whoever it is who's doing the monitoring, they're not even in the state of New Jersey. They're someplace else. They're remote. Okay, that's crazy that they're trying to throw this stuff in. And in states with fee schedules, they don't allow that type of chicanery, literal fraud, or bill padding. In New Jersey, you can get away with it, and they're trying to do that. So, look for those stuff. Look at the use of co-surgeons. Co-surgeons, particularly for simple procedures. You should not be paying as an employer or a carrier for a surgeon to train another surgeon and then both to bill the same amount on the surgery. That's just simply ridiculous. And I think especially suspect is outpatient surgical charges. There are many facilities that have just grown up or have been created simply to provide these surgeries, have people cross state lines, get these surgeries so they can bill enormous amounts. When you see that happening, that's a red flag. You should take a look at that. All right. I hope today's conversation was useful. As you can tell, this is a subject that I have a lot of excitement about. Unfortunately, these medical provider claims annoy me tremendously. I think there's a lot of chicanery going on here, a lot of ripping off of employers and carriers. It has continued to grow and grow and grow, and it's now about 1 in 5 new cases that is filed in the state of New Jersey, which is ridiculous. These cases can be defended. They should be defended with vigorous advocacy. You shouldn't be throwing money at these kinds of claims if you can prevent it. All right. So let's move on to questions and answers. If anyone has questions for me, I would love to hear them. I know that some people have their mics on or off. Let me open up the Q&A panel. Okay. So Lisa asked the question, first question, hey, Greg, can you give me a little bit more information about establishing a medical provider network? Yes, I can. And I'm not going to give out any free advertising here, but I will tell you that there are many very established provider networks that you can go and rent. So for example, in New York, here in my practice, our private health insurance is through Blue Cross Blue Shield. I got employees in like a lot of states, I think like 16 states or something. And so we have Blue Cross Blue Shield and its national plan, et cetera. Well, Blue Cross Blue Shield, New Jersey Blue Cross Blue Shield will also rent you their list or their contract so that you can just kind of use that as your medical provider network from a workers' compensation perspective. And what's good about that is they have tremendous penetrations. Probably something like 90% of physicians are in one of these provider networks. So I'm not giving an advertisement for Blue Cross Blue Shield. In my opinion, they're okay. But you can go to the market, you can Google, medical provider network established in New Jersey, and you will find that all of the major healthcare plan providers will also put together a plan for you as either a self-insured employer or as a carrier. And that's a very efficient way of assembling your own preferred provider network. You don't have to do it that way. Okay. You could say to yourself, hey, you know what? We like these 80 doctors. We like these 20 hospitals. That's who we're going to select as our preferred provider network. And you can literally create it because in New Jersey, you have the opportunity to control and direct care. It's always under your control. You can say yes or no to any treatment that is requested from the claimant or any treatment that's curative and necessary. So that's completely under your control. So I hope that's helpful to you, Lisa. All right. Anybody have any other questions? Are there any other new posts? Clicking. Okay. So Ryan asked the question, Greg, what, if any, New Jersey comp courts are actually moving these cases? And the answer is none. There is no urgency at all in this jurisdiction about this, and I'm very sorry to report that to you. Now, what did just cross my desk today? Well, first, you should just know that this is one of the axes that I grind about this jurisdiction. We're filing a motion. We're asking the court to intervene, to do something in the case. And then this is when the other party adjourns it. The judge continues the case. There's no decision making. So it's very frustrating. And I don't want to blame the jurisdiction because I think that's a sign of a weak attorney. He's always blaming the court for when they get bad outcomes. But this jurisdiction is especially frustrating in terms of the speed that it moves at. Okay. It does vary a little bit from judge to judge, but the truth, Ryan, is that these cases are relegated down pretty low on the list. And when I confront judges about it, because I do, when I confront them about it, I say, listen, this has been pending now for a year. I've got a motion to dismiss. I should be out of this. My client should not be paying me to be here. You should let us out of the case. You should dismiss the case, judge. And judge, even if you won't dismiss it, just issue an order saying you're denying my motion to dismiss. At least I can go appeal that, right? At least I can go make some case law on that. The judge will say things like, Greg, I need to focus my day on my motions for med intent, my open trials on issues of permanency. And Greg, these medical provider issues are way down here. And I go, I understand that, Your Honor, but these cases are of extreme high valuation. Again, the case that I demonstrated today in the presentation where they billed $360,000 for a 1-hour surgery. That's a high value. That's what is that? That would be about 70% of partial total win permanency award, right? So these should have some import or some attention from the courts. And I'm sorry to tell you, they just don't. Okay. Now, our policy here at Lois Law Firm is if we file a motion and the motion does not get heard by the judge the first time, we get it. If it gets adjourned for a reason for continuance, we get it. But if the second time the judge doesn't rule on the motion or at least set a date for the motion to be ruled on, then the attorneys that work here are to refer it to me. And my job is then to contact the administrative supervising judge of that vicinage, right? There's 15 local courts, and they each report to an administrative supervising judge and contact the supervising judge. Hey, Your Honor, nobody's paying attention to this. Could you please contact the assigned trial judge and get them to do something, right? So that's how we try to address it proactively to light a fire. And then the last thing, and this just crossed my desk, is once a year, we are allowed to fill out judicial surveys. And I put in them very clearly, like this judge does not pay attention to motions. This judge does not grant dismissals or hear dismissals. This judge does not respond to medical provider claims. Like I put that in my comments to the chief judge, the chief presiding judge, so that there is at least some feedback to them that, hey, these cases are not moving specifically or with any level of urgency. So I know it's a frustrating answer to give you, Ryan. And I hate saying, hey, this is a bad jurisdiction for judges actually, carrying out what they're supposed to be doing. It's our job as advocates to stand in front of those judges, be persuasive, and make sure that they actually do what they're supposed to do. And that's all we can do. All right. Any other questions in here? Let me check the chat. Okay. Don't see any. Anybody want to just unmute themselves and ask me a question? You're welcome to do that as well. I hear some people with their mutes off. Okay. And I don't get any takers on that one. I get it. Okay. All right. Other things you can do. Look, we have a great newsletter. If you want to subscribe to that, we'll give you up-to-date information on what's happening in New York and New Jersey workers' comp law. My door is always open. So if you have a question about New York or New Jersey comp law, you can always reach out to me or any of the great attorneys on our New Jersey practice who are happy to answer your questions. All right. I hope everybody has a great, hello? Did I lose you? I lost you. Oh, there you are. All right. I hope everybody has a great remainder of August and enjoy your summer vacation. And I'll see you in September. Bye now.